Good evening, everyone. Welcome to another live streaming of basic transfer pricing. Thank you sa ating mga subscribers. Ilan na hari?
967.
Okay, so thank you po sa ating mga subscribers. Umabot na po tayo ng 967 subscribers po dito sa Basic Transfer Pricing Philippines. And our topic for tonight is about the physical presence rule and the e-commerce and due process. And we will discuss the case of South Dakota versus Wayfair Inc. et al. No? And this case is on time because of the taxation of the digitized economy. No? Yung mga naririnig natin noon na hindi nagbabayad ng tax ang mga online sellers, hindi nagbabayad ng tax yung nasa e-selling, nasa internet na bintahan, hindi nagbabayad ng tax. This is a case, no? Dito inabandon yung dating decision na hindi sila dapat magbayad ng tax, no? Parang binago yung batas dito because of this case. No? Shout out. Wala tayong viewers?
Two viewers.
Ha?
2 viewers pa lang.
Okay, so shout out sa viewers natin, no? Anyway, tuloy lang tayo kasi recorded naman to, no? Hindi naman ibig sabihin na may viewers ka o wala. Once na na-publish mo na siya, continuous lang, no? And anybody can access. And then, nagkakaroon din ng viewers. No? So, yun yung para sa akin, ang internet, no? YouTube is tiyagaan din lang. Because if you stop, talagang wala. And para sa akin, para ka rin nagtatanim sa YouTube, no? Na hindi mo alam kung tutubo ba siya, hindi mo alam kung sisikat pa siya. Basta yung tama yung advice ng iba mga, basta upload ka lang ng upload, no? Kasi parang nagsusulat ka rin ng libro, parang author ka rin ng libro na basta sumulat ka lang and then i-publish mo siya. And it's up to the readers kung sisikat yung libro mo o hindi. Hindi mo malalaman na sisikat yan o hindi yan sisikat hanggat hindi mo pinablish, no? Parang ganyan din sa YouTube. Not unless na tuloy ka lang ng tuloy, upload lang ng upload, it's up to the viewers to say kung magbabiral ba o marami bang viewers yung ina-upload mo, no? So, thank you very much sa ating mga viewers at saka sa ating mga subscribers. And ano ba itong tinatawag dito na the physical presence rule, no? And also this e-commerce and due process. Itong sinasabi nila physical presence rule, this is all about the taxability of certain taxpayer or certain business entity sa isang lugar na wala naman siyang physical presence doon, kung hindi nagbebenta lang siya through the internet or through delivery, no? Yung hindi pa uso ang internet noon, uso na yung selling through catalog ang sa United States, no? Yung mga manufacturing companies, nagpapagawa sila ng catalogs, nandun lahat yung kanilang mga products, tapos pinapublish nila yung catalog nila and then anybody can order through the catalog, no? So may mga precedent na noon or may mga decision na doon ang court na pag walang physical presence ang isang business entity sa isang lugar, hindi siya magbabayad ng sales tax or yung tinatawag po natin na business tax, no? Hindi siya magbabayad. Itong case na to, yung South Dakota versus Wayfair, ito yung nag-abandon ng case. Kaya nga usapan dito ng mga judges yung about stare diseases. Why? Kasi yung stare diseases, pagka karoon na decision yung isang kaso at the same lahat ang circumstances or yung facts, hindi pwedeng i-abandon mo yung previously decided case, no? I-adapt mo yon at i-apply mo sa bagong case. But in this case, inabandon no? Kasi hindi na siya practical and because of the internet facilities na ngayon or online selling, nagde-deteriorate o na erode yung tax base ng isang bansa because ang nagbebenta o yung nakikinabang sa mga customer niya, sa mga residents niya na mga consumers, taga-ibang bansa na. So kung hindi sila magbabayad ng tax, mai-erode o kaya walan ng collection ang bansa na wala na din siyang gagamitin for the government, for the expenses of the government. So ito yung nangyari dito. At itong pinag-usapan din dito ang e-commerce, because of the advent, lalo na ngayon, iba na tayo, yung e-commerce na lahat-lahat ng buhay natin through online na, through internet. So talagang mag-iiba na rin yung batas. That's why yung sinasabi dito na due process, nag-iiba na rin, So this is the case of South Dakota versus Wayfair Inc. et al. At sinong decision dito po? Ito na yung Supreme Court of the United States. Umabot na po ito sa Supreme Court, And pinag-usapan dito yung tinatawag natin na stare decisis, to stand by things decided, So it is the doctrine of precedent na sabi ng korte, if there is already a case that has been decided with the same facts and circumstances of the case, do not abandon. But ang pwedeng gawin lang ng judge is to apply the same decision of the previously decided case, And ibig sabihin ng stare decisis is to adhere to decided cases and not to disturb settled questions. Kasi settled na bakit mo pababaguhin? Stare decisis it non quieta mo movere. Yun po yung Latin, Ito yung syllabus ng case, pero yung i-discuss ko sa inyo, ito na yung opinion na ng court, yung about the physical presence rule and the physical presence requirement, Okay. Pero itong syllabus ng case, which is the summary, ito yung sabihin ko sa inyo, and then we will go through what happened during the case, Okay. So in this case, South Dakota versus Wayfair Inc. et al., this was decided on June 21, 2018, So South Dakota, like many states, taxes the retail sales of goods and services in the state, sa state niya, yung tinatawag natin na sales tax, Sellers are required to collect and remit the tax to the state, but if they do not, then in-state consumers are responsible for paying a use tax at the same rate, So kung hindi magbabayad yung business entity o yung seller, sino magbabayad? Yung consumer, Parang yung ginagawa natin sa excise tax. Di po ba pag nag-import tayo ng mga goods and then hindi binayaran ng importer ang customs duties and the excise tax on that goods. So any person found in the position of untaxed or unpaid excise tax on imported goods, siya yung magbabayad. So ganito yung nila dito. Ginawa, So kung hindi magbabayad yung seller, the consumer will pay, But you can just imagine how burdensome for the state to collect from millions of inhabitants, Unless na dun sila magkokolekta sa business entity, isa lang yung magbabayad ng tax. Samantalang doon sa consumer, millions yung consumer. So topsy-turvy or very burdensome on the part of the state. And it is very costly to collect for the tax. Unlike na i-impose lang nila doon sa seller. Okay. Under National Bilas Hess Incorporated, ito yung precedent, Kaya nga nagkaroon dito ng tinatawag na stare decisis because this is the case decided na in favor doon sa seller na hindi sila dapat magbayad ng tax because they have no physical presence in the state. So hindi sila daw dapat magbayad ng sales tax. Okay. Also in the case of Hills Corporation versus North Dakota, no? South Dakota may not require a business that has no physical presence in the state to collect its sales tax, no? Kasi may batas eh. Pagka wala kang physical presence, then hindi ka dapat magbayad ng sales tax. Consumer compliance rates are notoriously low. However, and it is estimated that Bellas Hess and Quill cause South Dakota to lose between 48 and 58 million annually. So yun na yung result. Kasi hindi pinapabayad yung parang business with no physical presence in South Dakota, pero nagbebenta siya doon. Paano siya nagbebenta? Through delivery lang, through internet, no? Concerned about the erosion of its sales tax base and corresponding loss of critical funding for state and local services, the South Dakota legislature enacted a law. So, enact sila ng law. Anong ginawa doon sa law? Requiring out-of-state sellers to collect and remit sales tax as if the seller had a physical presence in the state. So kahit out-of-state ka, hindi ka taga South Dakota, basta nagbebenta ka sa South Dakota, then you have to collect the sales tax. The act covers only sellers that on an annual basis deliver more than $100,000 of goods or services into the state or engage in 200 or more separate transactions for the delivery of goods or services into the state. So nagkaroon sila ng threshold. Ano yung threshold? Sales of 200,000 and transactions of 200, no? 200 transactions during the year. Subject na sila, magkokolekta na sila ng sales tax. So yun po yung ginawa na batas, no? So magkano yung threshold? 100,000. Below 100,000 hindi ka magbabayad ng sales tax. And also below 200 separate transactions. Respondents top online retailers with no employees or real estate in South Dakota. Kasi bakit wala silang employee in South Dakota? Kasi wala silang physical presence, no? Paano sila nagbebenta? Through internet lang and then dinideliver lang directly to the consumer. It's meet the Act's minimum sales or transactions requirement but do not collect the state sales tax. So ito na, may ganong batas na sila na pag meron kang 100,000 na transactions during the year and 200 transactions and 100,000 na sales during the year, magbabayad ka na ng sales tax. Pero, yung mga business entity, no, hindi nila sinunod, no? Do not collect the state sales tax. South Dakota filed suit in state court. So, based on that law, si South Dakota filed a case in court, no? Seeking a declaration that the Act's requirements are valid and applicable. Hindi nila sinusunod yung batas kasi sabi nila hindi daw valid or unconstitutional. Okay, so are valid and applicable to respondents, and an injunction requiring respondents to register for licenses to collect and remit the sales tax. Respondent, sino yung respondent dito? Si Wayfair, no? Respondent sought summary judgment arguing that the act is unconstitutional. So, ganun yun. You have to attack the law, no? So, sabi niya dito, unconstitutional. So, ang batas, pag unconstitutional, hindi mo pwedeng apply. It's null and void. The trial court granted their motion. So, panalo sila sa trial court. The state Supreme Court affirmed on the ground that Quill is controlling precedent. Tapos, inaffirm pa din sila ng Supreme Court. Why? Kasi because of the case ng Quill, no? Precedent case siya. Ano yun? Na pag wala kang physical presence, hindi ka magbabayad ng sales tax. Held, because the physical presence rule of Quill is unsound and incorrect, Quill Corporation versus North Dakota and National Bellas Hess Inc. versus Department of Revenue of Illinois are overruled. Okay, so in this case, in-overruled nila, ibig sabihin in-abandon nila. So wala na yung starry diseases. Diba ano yung sa starry diseases? You have to left the decision undisturbed. In-abandon ng korte pagdating na dito sa North Dakota versus South Dakota versus Wayfair Inc. No? Overruled. So, inabandon. Hindi na sinunod. So, wala na stare decisis dito. An understanding of the court's commerce clause principles and their application to state taxes is instructive here. So, dito, in-explain ng korte kung ano yung commerce clause principle. At saka yung due process. At saka yung tinatawag dito na physical presence, no? Business with a physical presence. The two primary principles mark the boundaries of the state's authority to regulate interstate commerce. State regulations may not discriminate against interstate commerce, and states may not be imposed undue burdens on interstate commerce. These principles guide the courts in adjudicating challenges to state laws under the Commerce Clause. They also animate Commerce Clause precedents addressing the validity of state taxes. So, talagang inattack nila yung Commerce Clause as to the validity ng state taxes, no? Kasi ayaw nila magbayad. Which will be sustained so long as they apply to an activity with a substantial nexus with the taxing state. Ano yung substantial nexus to the substantial nexus with the taxing state? Ano ibig sabihin nun? Substantial connection, no, with the taxing state. Ano yung connection na yun? Siyempre, ikaw you're doing business in a state. Ano yung connection mo doon? Siyempre, yung mga customer at saka yung sales na ginawa mo doon sa state. No? So, yun yung substantial nexus. Are fairly apportioned, do not discriminate against interstate commerce, and are fairly related to the services the state provides. Okay. The court held in Velasquez that a seller whose only connection with customers in the state is by common carrier. Bakit common carrier? Kasi delivery. No? Nagdi-deliver lang yung connection nila. Pero para sa akin, delivery is just one of the connection. Why? Kasi ano ba yung dineliver ng carrier? Di ba goods? And then out of that delivery, nagbayad yung purchaser o yung buyer doon sa seller. So it's more than the carrier. The nexus is more than the carrier. The nexus talaga is the sales, no? Yung delivery ng goods of the seller and also the payment of the price by the supplier. Yun yung nexus. Yun yung connection, no? Carrier or mail lack the requisite minimum contacts with the states required by the due process clause. Kasi para may due process clause daw, there should be a physical presence and hindi daw enough yung nexus nila or connection nila na through carrier lang by mail. No? So, unless the retailer maintained a physical presence in the state lacked the power to require the retailer to collect the local tax. So, ang gusto nila talaga, may physical presence yung seller sa state, no? Which is impossible right now. Bakit? Kasi through internet na lahat. Lalong-lalo na ngayon. Ito kasi 2018 pa ito nangyari. So, lalong-lalo na ngayon, 2021. Ano nang nangyari sa mundo ngayon? Wala na physical presence ang mga online sellers, no? You can sell your goods all over the world. Wala nang, and then, pa-deliver mo lang yan sa carrier, no? Pero wala nang physical presence, no? In Quill, the court overruled the due process holding but not the Commerce Clause holding, grounding the physical presence rule in complete autos requirement that a tax have a substantial nexus with the activity being taxed. Siyempre, yung tax talaga may connection siya doon sa thing that is being taxed, no? So, or activity. So, ano yung activity? Selling. Ano ba yung purpose ng selling? Business, no? Because you are selling goods for profit. As an economic entity, ang kailangan mo dyan, profit. So, anong ginagawa mo? Bili mo ng certain price. Pagka binenta mo, minamark upan mo because you want profit. No? So the physical presence rule has long been criticized as giving out-of-state sellers an advantage. Correct ka dyan. Bakit? Kasi yung physical presence rule, halimbawa, marami kayong mga business players or sellers in the state. Marami din yung mga sellers outside which are selling also. May market share din sila sa mga customers ng state. So you are giving them an advantage. Why? Kasi yung mga nandito may physical presence nagbabayad, pero yung mga malalaki without physical presence hindi nagbabayad. So you are giving them advantage, no? Meron tayong taxation on the digitized economy. Kailan yung ano natin, Hari? Nandyan yung schedule ko eh. Akin na nga, basahin ko sa kanila. Nandyan no, sa likod. Kasi meron tayong on the transfer pricing on the digitized economy. No? Ito po. We have seminars on YouTube din ito via basic transfer pricing. So bukas, we have free webinar on the preparation of transfer pricing documentation. This is 10 to 12 noon. No? And then yung sa 23 natin, 2 to 4 p.m. naman, free webinar on comparability analysis and when to make a comparability adjustment. No? So we will discuss there ilang klase ba ng adjustment kasi we have primary, secondary, and then supplementary na adjustment. And then on June 24, we have free webinar on transfer pricing and digitized economy. No? So doon ma-discuss ito yung ano ba yung mga activities na being taxed and then yung mga advantages ng mga sellers without any physical presence. So meron tayo niyan that is in June 24. In June 25, we have free webinar on transfer pricing and permanent establishment. Ano itong permanent establishment? Isama na rin natin siguro sa discussion dyan yung mga brands and subsidiaries. No? At saka kailan naging permanent establishment yung isang entity na may business activity dito sa Pilipinas. No? And it will be taxed as permanent establishment considered as brands. On June 29, we have the free webinar on transfer pricing and tax treaties. No? So, tax treaties naman kasi pag nagbenta ka na, you are having income in other countries, ang una-una mong tanongin dyan kung how much ba yung babayaran mong tax sa kanila is you have to consult a tax treaties, especially if that country has a tax treaty with your country. On June 30, we have free webinar on international taxation and transfer pricing. Very important po. Why? Kasi because of the advent of digitized economy, meron na tayong tinatawag na international taxation. Why? Because the taxation has no boundary na ngayon. No? So, kahit saan ka, pwede ka nang magbenta. Wala nang limitations. Bakit pwede ka nang magbenta? Through the internet. No? So, kailangan mag-update din yung ating legislators so that nakaka-cope up tayo on the collection of taxes. No? Okay. So the physical presence rule has long been criticized as giving out of state sellers an advantage. No? May advantage sila kasi pagka nandun sila sa labas ng bansa but they are selling goods inside the country, hindi sila nababayad ng tax. So, that out-of-state sellers has an advantage of not paying the tax. Each year, it becomes farther removed from economic reality and result in significant revenue losses to the states. So, ano nangyayari? Naglo-loss yung states. No? Nagkaroon siya ng uncollected. No? And in this case, sa North Dakota, no? Tama ba? South Dakota. In this case, na South Dakota, 60% ng collection niya is coming from the sales tax. So, tanggalin mo yon o kaya bawasan mo yun ng 20%. Napakalaking effect sa kanilang revenue. This critic underscored that the rule both as first formulated and as applied today is an incorrect interpretation of the Commerce Clause. Quill is flawed on its own terms. First, the physical presence rule is not a necessary interpretation of complete Otus nexus requirement. That requirement is closely related bilas his to the due process requirement that there be some definite link, some minimum connections between a state and the person, property or transaction it seeks to tax. Dapat daw may connection yung property or person to be taxed with the state. No? Kaya nga, inahanapan nila ng physical presence in the state bago mo siya pwedeng i-tax. And as Quill itself recognized, a business need not have a physical presence in a state to satisfy the demands of due process. So sa Quill case, na-recognize na niya na yung physical presence hindi kailangan. No? When considering whether a state may levy a tax, due process and commerce clause standards, though not identical or coterminous, have significant parallels. No? So the reasons given in Quill for rejecting the physical presence rule for due process purposes apply as well as the question whether physical presence is a requisite for an out-of-state seller's liability to remit sales tax. Bakit out-of-state seller siya? Kasi wala siyang physical presence in the state, situated siya in other state, pero nakakapag-connect siya even to the biggest buyer, no? Nakakapag-connect siya through the internet. Other aspects of the court's doctrine can better and more accurately address potential burdens on interstate commerce, whether or not Quill's physical presence rule is satisfied. So sa Quill, yun yung precedent na case, the physical presence rule is required. No? Second, Quill creates rather than resolves market distortions. In effect, it is a judicially created tax shelter for businesses that limit their physical presence in a state but sell their goods and services to the state's consumers, something that has become easier and more prevalent as technology has advanced. So, as technology has advanced, yung mga seller, meron na silang access to the buyer anywhere in the world. No? So, hindi na kailangan ng physical presence. Actually, sino ba yung architect of change in the world? Ito yung ating mga multinational enterprises, ito yung mga businessmen natin. Why? Kasi it evolves through their needs, no? So needs nila to do business all over the world. So gumawa sila ng mga discovery, research and development through telecommunication so that na monitor nila yung mga businesses nila all over the world. Kaya ang tawag nga sila sa kanila, they are the architects of the world, no? So because of this advanced technology, madali na lang yung gumawa ng business all over the world. No? So the rule also produced an incentive to avoid physical presence in multiple states. Ano yung incentive nila? Hindi sila natatax doon sa state kung saan sila nagbebenta. No? Affecting development that might be efficient or desirable. So since hindi sila nagbabayad ng tama doon sa country or the state kung saan sila may business, then ano yun? Distorted yung tax collection naman nung bansa na yon. Third, Quill imposes the sort of arbitrary, formalistic distinction that the court's modern commerce clause precedents disavow in favor of a sensitive, case-by-case analysis of purposes and effects. No? So, ano yung sinasabi dito na formalistic distinction? No? That the court's modern commerce clause precedent is avow in favor of sensitive case-by-case analysis of purposes and effects. Okay. It treats economically identical actors differently for arbitrary reasons. For example, ito yung critics nila against the physical presence, no? Or in favor sila sa hindi itatax yung walang physical presence. For example, a business that maintains a few items of inventory in a small warehouse in a state is required to collect and remit a tax on all of its sales in the state, while a seller with a pervasive internet presence cannot be subject to the same tax for the sales of the same items. So ito lang kinumpare nila, yung business na may internet connection at saka yung business na ng internet connection or physical presence lang. And who has the advantage? Of course, yung may internet connection. Why? Kasi nakakapagbenta siya anywhere in the world, nakakapag-penetrate siya ng market, no? So sino may advantage? Siyempre yung may internet connection. When the day-to-day function of marketing and distribution in the modern economy are considered, it becomes evident that Quill's physical presence role is artificial, not just at its edges. So ang nire-require daw ng Quill na physical presence is artificial. Ibig sabihin ng artificial, walang substance, no? Artificial, parang ano lang siya, yung in favor siya sa taxpayer, sa business entity, but of course, against siya sa taxing authority. Bakit? Kasi hindi na makakolekta yung taxing authority dito. Okay. Modern e-commerce does not align analytically with a test that relies on the sort of physical presence defined in Quill. No? So, dapat na lang din talaga i-abandon kasi e-commerce na tayo ngayon, pero yung Quill require pa rin ng physical presence. And the court should not maintain a rule that ignores substantial virtual connections to the state. The physical presence rule of Bellasens and Quill is also an extraordinary imposition by the judiciary on states' authority to collect taxes and perform critical public function. Ito yung mali nila kasi kagaya sa atin sa Pilipinas, yung tax laws natin, nag-i-emanate lang siya sa lower house, which is in Congress. Kahit na yung Senate, hindi siya pwede magdiretso na lang, no? Doon talaga manggagaling. So, dapat, anong ginawa nila dito? Hindi nagkaroon ng judiciary lang na opinion, but it should have law emanating from Congress, no? Kasi i-determine nila kung ano ba talaga yung dapat may physical presence ba o wala, no? So, 41 states, 2 territories, and the District of Columbia have asked the court to reject Quill test. No? So, ilang states ito na sama-sama sila na i-reject yung Quill's test. Ibig sabihin, i-abandon yung Quill's test. Helping respondents' customers evade a lawful tax unfairly shifts an increased share of the state to those consumers who buy from competitors with a physical presence in the state. So, anong mangyayari? Advantageous sa customer, sa business, no? It is essential to public confidence in the tax system that the courts avoid creating inequitable exceptions, no? So, inequitable exceptions. And it is also essential to the confidence placed in the court's commerce clause decisions. By giving some online retailers an arbitrary advantage over their competitors who collect state sellers' taxes, Quill's physical presence rule has limited the state's ability to seek long-term prosperity and has prevented market participants from competing an even playing field. So yan ang mga disadvantages doon sa physical presence rule. Starry diseases. Ano tong starry diseases? Yung sabi natin na yung previously previous decision na should be left undisturbed. Wala ka nang magawa if you are the judge. Meron ng decision yung isang kaso, same doon sa hinawakan mong kaso, wala kang magawa but to apply the previous decision in your case. No? So, in this case, starry diseases can no longer support the court prohibition of a valid exercise of the state's sovereign power. Pero ano sabi nila dito? Hindi na pwede yung previous na court decision, inabandon na. Kaya nga wala na yung starry diseases. Pakipatay yung ano?
Shoutout tayo.
May shoutout. Sige, shoutout muna.
Shoutout po kay Manuel de la Cruz.
Okay.
Apo.
Participant natin siya, di ba?
Ako nung nakaraan.
Okay. So, shoutout sa iyo, Sir Manuel de la Cruz.
Good evening daw po, ma'am.
Okay.
Pati po kay Sir Eugene Cruz, good evening daw po.
Na, ano siya, yung ilan na yung viewers natin?
8 viewers, ma'am.
Okay. So, thank you very much. Good evening din kay Sir Eugene. No?
Pati po kay Raiches. Good evening daw, ma'am.
Okay.
Sorry daw, ma'am, na late siya.
Oh.
Raiches.
Righteous, good evening din po. No?
Pati po kay Miss Cupcake.
Oo,
Good evening
nandiyan
po.
din si Miss Cupcake. No, attend ka, Miss Cupcake, sa ating mga free na seminar, no? Kasi sabihin nyo na hindi applicable sa amin yung transfer pricing ngayon. At least meron tayo yung sa taxation on digitized economy. Later on, ma-appreciate nyo rin siya at maintindihan nyo, ito pala yun. No? Okay, meron pa?
Kay Miss J kay Miss J po, shout out din. Good evening
Okay,
daw.
shout out Miss J.
Sila pa lang.
Okay. Sige, tuloy tayo kasi maganda po ito. This is on time na case dahil nga internet na tayo ngayon But still our states or countries still has a difficulty in collecting taxes on online seller, no? Kahit na tayo, yung tinitingnan ko yung mga e-tax receipt nila, it doesn't conform with the receipt requirement natin dito sa Pilipinas Kaya ang daming nagtatanong, ma'am, yung resibo ng online supplier ko, pwede na ba ito? Siyempre, pagka yung batas natin, the local tax legislation po natin, yung ating tanungin, hindi siya pwede. Pero dapat din, kaya nga in this case, ano sabi ng judge dito, left it to the legislation, no, para i-refine pa nila yung batas. Kaya dapat sa atin ganun din. Although nakita ko sa digitized economy natin, may taxation of digitized business. Meron ng propose si representative sa LCTA, no, ng Bicol, pero hindi pa yun na-postro. At saka tiningnan ko, parang kulang siya. Parang ang hirap niya i-implement if ma-approve siya. So parang more, make it more specific para hindi siya mahirap i-apply, no, i-administer later on. Okay, madali lang naman yan kasi yung mga ibang bansa, just like Japan, matagal na silang may e-commerce law May mga yung taxation of nila ng digitized business, matagal na sila. No? So, we will just pattern our domestic law, if ever, dun sa mga bansa na tested and proven na yung kanilang mga batas. No? Ganun lang ang buhay No? Kung mahirapan ka magdesisyon sa sarili mo, then try to look at the decision na ginawa ng iba para sa same problem, no? Para meron kang, kumbaga, sa ano basihan ng gawin mong decision. Okay, so if it becomes apparent that the court's commerce clause decisions prohibits the states from exercising their lawful sovereign powers, the court should be vigilant in correcting the error, no? Kasi pwede rin naman na magkaka-error ba kahit na yung korte nagkaka-error yan. So, but it should be corrected. It is inconsistent with this court's proper role to ask Congress to address a false constitutional premise of this court's own creation, no? So, kasi gumawa na ng decision yung, pero para sa akin, wala ding error yung court Why? Kasi iba naman yung, situation nung time, no, na ginawa nila yung decision na yun at iba sa ngayon. So para sa akin wala din namang mali yung court or hindi rin naman sila nagkakaroon ng ganun sinasadya na error or mistake. But as the time evolved and the digitized economy evolved, pwede mo ring i-abandon na yung previous na decision. Why? Kasi hindi na sila applicable. The internet revolution has made quill, original error, all the more egregious and harmful, no? Kasi iba na napakalakas na ng sales through the internet. Ikaw hindi mo i-tax yung internet, saan ka pa kukuha ng tax mo? No? So, madidrain na ng revenue yung state. Just like in this case, 60% ng collection ng South Dakota is coming from the sales tax. Yung sales tax nandoon na, hindi na kukolekta. No? So the Quill Court did not have before in the present realities of the interstate marketplace where the internet's prevalence and power have changed the dynamics of the national economy. The expansion of e-commerce has also increased the revenue shortfall faced by states seeking to collect their sales and use taxes, leading the South Dakota legislature to declare an emergency. No? So, nag-declare ng emergency yung South Dakota. The arguments, moreover, that the physical presence rule is clear and easy to apply is unsound. No? Kasi yung physical presence, wala na eh. Virtual presence na tayo ngayon. And we also have virtual community, kaya we have the virtual market. An attempt to apply the physical presence rule to online retail sales have proved unworkable. So, ang physical presence mo, i-apply mo sa online seller or online retail sales, hindi siya applicable. Because the physical presence rule as defined by Quill is no longer a clear or easily applicable standard, arguments for reliance based on the clarity are misplaced. No? Star diseases may accommodate legitimate reliance interest. Kasi kaya nga yung doctrine ng star diseases, pwede din niyang i-apply ng court. Pwede rin naman siyang i-abandon, no? Kasi may reason eh. United States versus Ross, but a business is in no position to found a constitutional right on the practical opportunities for tax avoidance. Okay. Ano yun? Opportunities for tax avoidance, pagka tinuloy-tuloy mo na hindi mo itatax yung online seller because hanapan mo pa sila ng physical presence. Iba na yung mundo natin. Startups and small businesses may benefit from the physical presence rule, but here, South Dakota affords small merchants a reasonable degree of protection. Kasi sa South Dakota naman yung rule nila is may threshold, di po ba? 100,000 na sales at saka more or less 200 transactions para maging subject yung online seller sa sales tax. Finally, other aspects of the court's Commerce Clause doctrine can protect against any undue burden on interstate commerce, taking into consideration the small businesses, startups, or others who engage in commerce across state lines. The potential for such issues to arise in some latter case cannot justify retaining an artificial, anachronistic rule that deprives states of vast revenues from major businesses. Sino yung major businesses? Lalo na kung yung major businesses mo nasa online na, no? So in the absence of Quill and Bilas Hess, the first prong of complete auto-test simply asks whether the tax applies to an activity with an substantial nexus with the taxing state. Here, the nexus is clearly sufficient. Ano yung nexus mo dito or connection or relation? Yung pagbenta niya dun sa mga resident mo, no? So the act applies only to sellers who engage in significant quantity of business in the state, and respondents are large national companies that undoubtedly maintain an extensive virtual presence, no? So virtual presence, walang physical presence. Any remaining claims regarding the Commerce Clause application in the absence of Quill and Bilas Hess may be addressed in the first instance on remand, no? So ni-remand sa court to decide. Vacated and remanded, no? So ito yung nangyari sa case na to. Anyway, may mga dissenting opinion, no? Pero yung talagang nagbigay dito ng opinion, ito si Justice Kennedy, no? Deliver the opinion of the court, no? And then may mga concurring decision din at saka may dissenting opinion, no? Okay. So maganda ito, mahaba lang at hindi natin ito matapos ng 2 oras, no? Although yung summary or yung syllabus ng case na bigay ko na sa inyo, ang ibigay ko sa inyo yung decision na lang ni Justice Kennedy, no? Dito sa case na to, which is very good kasi binigay niya yung reason why ganyan yung decision niya, no? Sabi ni Justice Kennedy, when a consumer purchases goods or services, the consumer state often imposes a sales tax. Ano tong sales tax? Ito yung business tax. Sa Pilipinas, ano tong tinatawag natin? Kasi may sales tax tayo noon, prior to 1988, the adoption of value-added tax. Itong sales tax is a business tax, no? Sa atin, ano yung business tax natin? Value-added tax at saka percentage taxes. Ilang klase yung mga percentage taxes natin, no? So, sa kanila, sales tax. Sa atin, VAT. Kasi, when we adopt the value-added tax system of taxation in 1988, pinalitan ng VAT yung 1.5% na subsequent sales tax. Kasi ang dami nating sales tax noon may 18% para sa mga yung luxurious na mga items na binibenta, no? Tapos meron tayong tinatawag na essential, no? So may 10%, may 18%, may 25%. So, sa VAT, ginawa na lang at the time, yung unang dating talaga ng VAT sa atin, noong 1988, ginawa na lang 10%, no? Okay. So, yan ang business tax sa atin. Sa kanila naman, 4% na sales tax, no? So, this case requires the court to determine when an out-of-state seller can be required to collect and remit the tax. So, sino yung magre-remit ng tax na yan? Kasi sales tax yan eh. So, yung gumawa ng sales, yung nagbenta, siya yung liable. So the seller can be required to collect and remit the tax. All concede that taxing the sales in question here is lawful. So may legal basis. Ibig sabihin, legal siya pagka tinax mo yung sales. Why? Kasi kaya nga siya tinawag na sales tax. Kasi tax siya on sales. So the question is whether the out-of-state seller can be held responsible for its payment. And this turns on a proper interpretation of the Commerce Clause. Dito na yung question, kung ba yung out-of-seller, dapat din siyang magbayad ng sales tax, no? Okay. In 2 earlier cases, the court held that an out-of-state seller's liability to collect and remit the tax to the consumer state depended on whether the seller had a physical presence in that state, but that mere shipment of goods into the consumer state following an order from a catalog did not satisfy the physical presence requirement. Sino daw magbabayad ng sales tax? Yung may physical presence sa state. No? So, yun yung mga previous decision. The court granted certiorari here to reconsider the scope and validity of the physical presence rule mandated by those cases. So, wala namang magawa kasi yung judge. Anong gagawin ng judge? I-apply yung batas. Wala namang batas na itatax mo yung entity na walang physical presence, no? Kaya nga, sinabi pa nila dito yung stare decisis, yung mga previous decisions. Yun din ang handicap ng judges kasi hindi ka pwedeng magbigay ng kahit sabihin mo nga naman for practical reasons or whatever, hindi ka pwedeng magbigay ng decision without a legal basis, no? Kaya anong dapat dito? It's the Congress gagawin talaga na batas bago mo ma-implement. No? Lalo na taxation dito sa atin the law on taxation shall emanate from the lower court, no? Like most states, South Dakota has a sales tax. It taxes the retail sales of goods and services in the state. Sellers are generally required to collect and remit this tax to the Department of Revenue. If for some reason the sales tax is not remitted by the seller, then in-state consumers are separately responsible for paying a use tax at the same rate. So, hindi siya kinolekta ng seller, yung consumer ang magkukolekta. So, many states employ this kind of complementary sales and use tax regime. So, under this court's decision in Belashes and Quill, South Dakota may not require a business to collect its sales tax if the business lacks physical presence in the state. Without that physical presence, South Dakota instead must rely on its residents to pay the use tax owed on their purchases from out-of-state sellers. No? The impracticability of this collection from the multitude of individual purchasers is obvious. So there's very high cost to collect kasi sa dami-dami ng consumer na itatax mo. At saka hindi yan lahat magbabayad. And consumer compliance rates are notoriously low. Pag consumer yung pinabayad mo, mas marami yung hindi magbabayad. No? Okay. Report to congressional requesters. Sales taxes, states could gain revenue from expanded authority, but businesses are likely to experience compliance cost. No? Mas mataas ang compliance cost. No? Okay. In South Dakota alone, the Department of Revenue estimates revenue loss at 48 to 58 million annually, particularly because South Dakota has no state income tax. Ito na yung sinasabi ko sa inyo na 60% ng collection ng South Dakota is coming from the sales tax, no? Particularly because South Dakota has no state income tax. No, wala siyang income tax. It must put substantial reliance on its sales and use taxes for the revenue necessary to fund essential services. Those taxes account for over 60% of its general fund. So yung sales tax, yan ang inaasahan ng South Dakota. So kung hindi yan properly collected, hindi magbabayad yung mga sellers, wala nang pondo yung South Dakota, no? Unlike here sa Philippines, 60% naman, no? 50 to 60% of the collection natin is coming from income tax. Sa kanila yung South Dakota is walang income tax. So 60% ng kanyang collection coming from the sales tax. No? So kung hindi magbabayad ng sales tax yung sellers, wala siya, kulang yung kanya revenue for the expenses of the government. In 2016, South Dakota confronted the serious inequity, no? Kasi nawawalan siya ng collection. Quill imposes by enacting an act of. So, para sagutin yung inequity na yun, noong 2016, yung South Dakota, gumawa sila ng batas. Ano yun? An act to provide for the collections of sales taxes from certain remote sellers to establish certain legislative findings and to declare an emergency. Nag-emergency na siya. Bakit? Kasi wala ng collection. No? The legislature found that the inability to collect sales tax from remote sellers was seriously eroding. Kaya nga yun din yung ginagawa ng OECD, no? Yung kanilang initiative, yung base erosion and profit shifting. Kasi nai-erode yung tax. Hindi na nakakolekta ng tax. Because of that, nawawala yung tax base, no? So, eroding the sales tax base and causing revenue losses and imminent harm. Siyempre, pag wala ng, kaya nga nagkaroon po ng transfer pricing because of this, no? Wala ng collection ang company. So, kung wala ng collection ang company, saan pa kukuha ang, wala ng collection ang state, so saan sila kukuha ng panggastos to support the services na ino-offer nila sa mga tao? Wala na. So through the loss of critical funding for state and local services, the legislature also declared an emergency. Imagine, red light na yung state. Whereas this act is necessary for the support of the state government and its existing public institutions. Kasi pag hindi mo i-tax yung online sellers, andyan na yung business, wala ka ng collection. An emergency is hereby declared to exist. Imagine, no? Magre-red light ka na. Parang emergency ka na talaga. Fearing further erosion of the tax base, the legislature expressed its intention to apply South Dakota sales unused tax obligation to the limit of federal and state constitutional doctrines and noted the urgent need for this court to reconsider its precedents. Oh? So, anong ginawa ng batas, no? Constitutional doctrine para i-reconsider daw ng court yung kanyang previous decisions. To that end, the act requires out-of-state sellers to collect and remit sales tax as if the seller had a physical presence in the state. As if, ha? Kaya yung mga previous case din ng transfer pricing dito sa Pilipinas, yung sinasabi nila na assume, no? Yung inassume lang, hindi rin na nanalo sa korte, no? Kaya nga dapat yung mga wordings din pagdating sa batas natin, piling-pili din at really applicable para hindi mahirap pagdating na sa implementation. Okay, so to that end, the act requires out-of-state sellers to collect and remit sales tax as if the seller had a physical presence in that state. No? The act applies only to sellers. Ito yung sabi kong may threshold. That on an annual basis deliver more than 100,000 of goods or services into the state or engage in 200 or more separate transactions. Threshold, ibig sabihin, pag hindi mo narating yun, hindi ka subject, no? For the delivery of goods or services into that state. The Act also forecloses the retroactive application of this requirement and provides means to the Act to be appropriately stayed until the constitutionally of the law has been clearly established. Respondents Wayfair Inc., Overstock.com Inc., and Newwig Inc. Kaya nga ang respondent dito, Wayfair Inc. et al., no? Kasi marami sila are merchants with no employees or real estate in South Dakota. Bakit wala silang employee? Kasi wala silang physical presence. Wayfair Inc. is a leading online retailer of home, goods, and furniture and had net revenues of over 4.7 billion last year. Imagine, no? 4.7 billion. Multiply mo yan by 4% the sales tax. Napakalaki. Ito namang 4.7 billion, kolektahin mo yan sa consumer. Sobrang hirap. Una-una, hindi mo matag kung sino yung mga consumer nun. Overstock.com Inc. is one of the top online retailers in the United States, selling a wide variety of products from home goods and furniture to clothing and jewelry. And it had net revenue of over 1.7 billion last year. Madrain nga yung isang bansa, no? Kasi nandun na lahat yung sales. Newwig Inc. is a major online retailer of consumer electronics in the United States. Each of these three companies ships its goods directly to purchasers throughout the United States. Oh, wala siyang physical presence. So, pwede ba hindi mo siya i-tax? Naubos na niya yung consumer mo, wala kang tax. Including South Dakota, it's easily meets the minimum sales or transactions requirement of the Act. Ano yun? Yung 100,000 sales at saka 200 transactions. But none collects South Dakota sales tax. Oh, pero mo 4.7 billion yung sales niya pero walang nangolekta ng South Dakota tax. No? So pursuant to the Act's provisions for expeditious judicial review, South Dakota filed a declaratory judgment action against respondents in state court seeking a declaration that the requirements of the Act are valid and applicable to respondents and an injunction requiring respondents to register for licenses to collect and remit sales tax. So talagang nag-file siya ng injunction, no? Kaya nga certiorari ito sa Supreme Court eh. Ano yun? Kino-question na nila yung decision. No? Respondents move for summary judgment arguing that the act is unconstitutional. Unconstitutional daw yung act na ginawa ng South Dakota. South Dakota conceded that the act cannot survive under Villas, Hess, and Quill, but asserted the importance, indeed the necessity of asking this court to review those earlier decisions in light of current economic realities. Siyempre, yung decision mo o yung batas mo, kailangan naka-align yan with the present economic realities. Kasi gagawa ka pa rin ng same decision na nakaraan, ibang economic realities yun. So, hindi na tama yung magiging decision mo. So, the trial court granted summary judgment to respondents. The South Dakota Supreme Court affirmed. No? So, it stated, however, persuasive the state's arguments on the merits of revisiting the issue. Kasi yung batas na ginawa ng South Dakota, ito yung kinwestiyon ng Wayfair na unconstitutional. No? Ano yun? Yung taxing the company with no physical presence. Okay, so Quill has not been overruled, remains the controlling precedent on the issue of commerce clause, limitations on interstate collection of sales and use taxes. So this court granted certiorari. So question talaga sa Supreme Court yung decision. No? So the Constitution grants Congress the power to regulate commerce. So yun yung sabi nila. Kasi yung Constitution is the highest law of the land. So, anong sabi niya dito? Nag-grant siya ng power to regulate the commerce, no? Yung Congress. Among the several states, The Commerce Clause reflects central concern of the framers. That was an immediate reason for calling the Constitutional Convention, the conviction that in order to succeed, the new union would have to avoid the tendencies toward economic balkanization that had plagued relations among the colonies and later among the states under the Articles of Confederation. Although the Commerce Clause is written as an affirmative grant of authority to Congress, this court has long held that in some instances, it imposes limitations on the state absent congressional action. No? Kasi ang batas natin, dapat proactive din yan eh. Dapat kung ano yung current, kung ano yung applicable, nag-i-evolve din yung batas natin. Of course, when Congress exercises its power to regulate commerce by enacting legislation, the legislation controls. No? But this court has observed that in general, Congress has left it to the courts to formulate the rules to preserve the free flow of interstate commerce. Di ba, ano ba ang rule ng court? Ano din ba yung rule ng Congress? Siyempre, ang rule naman ng court is to implement the law, no? Di naman sila pwedeng gumawa ng iba't ibang interpretation. To understand the issue presented in this case, it is instructive first to survey the general development of this court's Commerce Clause principles and then to review the application of these principles to state taxes. So, yun, alam na natin na yung nangyari dito in this decision, inabandon ng court yung previous decision. Kaya yung stare decisis or yung you have to left undisturbed yung previous decision na hindi nangyari dito sa case na to. Because, of course, ano ba ang pinaka-importante para sa isang state? Survival. Eh kung continue nila yung mga previous decision na yon, which is against the economic realities at present, then wala na, mawala ng revenue yung state na wala na rin, hindi na makasurvive and cannot give services to its citizens, no? So, yun po yung nangyari dito sa case na to. May mga, ano pa tayo, Hari?
May viewers pa, ma'am. 8 viewers.
Okay. So, in this case, no, the due process clause and the commerce clause, very, ano na rin to, timely sa atin ngayon because of the online selling, no? So, ano ba? Balikan natin yung sa international law na, international taxation naman natin. Ano ba yung consensus sa VAT? VAT is a tax on consumption. It is a business tax, but it is a tax on consumption. Pag sinabi mo tax on consumption, it follows where the goods is consumed. So, saan mo siya itatax? Halimbawa, kagaya nitong mga pinag-usapan dito, saan ba sila dapat itax? At the place of consumption. So, halimbawa, binenta siya sa South Dakota, doon siya i-consume. So, dapat yung VAT doon din sa South Dakota babayad. That's why, sa atin, di ba, ang mga imported goods, yung imported goods natin are advance payment ng tax. Why advance payment ng tax? Kasi yung importation natin, sino nangongolekta ng VAT dyan? The customs. The moment the goods papasok dito sa Pilipinas, dadaan sa customs, yung customs, kukolektahin na niya yung customs duties and at the same time, kolektahin din niya yung VAT. No? Kaya bayad na yung VAT pagpasok pa lang dito sa atin because on the notion na that goods na pumasok dito sa Pilipinas will be consumed here in the Philippines. Ito namang mga export, bakit sila zero-rated? On the notion or belief or assumption that that goods will be consumed outside the Philippines, kaya hindi kinukolekta ang VAT, no? Kaya noon para ako, bakit pag imported subject to VAT? Bakit pag export walang VAT? Unfair naman, no? Yun yung nasa isip ko. Pero nung naintindihan ko na sa international taxation na yun pala ang consensus, no, ng mga bansa natin, ano yung consensus nila. Pagdating ng VAT on consumptions, pero yung income, kung sino yung nag-generate or may-ari ng income, doon siya itatax, no? Although, may case of double taxation when it comes to income because nag-iiba ang local or domestic law ng bawat bansa. Na pagka resident nila, itatax nila kahit saan galing pa yung income. Kung itatax din yan ng source country, itatax din ng resident country, kaya nagkakaroon ng case of double taxation. Pero sa income tax lang yon. Pagdating na sa VAT, sa business tax, dapat walang double taxation because very clear na yung provision na once it is a business tax, it is a tax on consumption. So, saan siya i-tax? At the place of consumption. So walang ano doon, walang question. Ang income lang ang maraming case of double taxation. No? So, yung free webinar po natin, continue tayo bukas 10 to 12 noon. Yun yung free webinar on the preparation of transfer pricing documentation. Na ano ko kasi yung topic natin, no? Sa 2 hours, parang bitin na ako. No, yung topic natin kasi sa documentation, meron tayong master file, local file, yung OECD na transfer pricing requirements, pero pahapyaw ko lang yon. Meron tayong documentation requirements ng RR2-2013, which is the transfer pricing guidelines. Meron din tayong requirements during the transfer pricing audit. At yung BIR Form 1709, yung latest na RR 34-2020. So we have to discuss them all in documentation. Kaya tingnan ko lang kung sana ma-overview na lang din yung mabibigay namin because 10 to 12 ito, no? 2 hours. Itong 23, we have free webinar on comparability analysis and when to make a comparability adjustment, no? Itong comparability analysis, alam nyo, dito ako nahihirapan. Kasi when you make a transfer pricing analysis, gagawa ka ng parang opinion mo, no, na arm's length talaga ang client mo. But in the end, hindi talaga sila arm's length Pagka gumawa ka ng study, hindi sila arm's length, you have to require them to make an adjustment, no? And then when you require them to make an adjustment, yung management ayaw naman mag-adjust, no? So yun ang hirap pagdating na sa actual, no? But ganun pa man, we will discuss how to make a comparability analysis at pag hindi talaga siya comparable, kasi di ba sabi natin, sa arm's length principle, dapat comparable yung independent party transactions with the related parties. So based on your analysis, hindi sila similar or hindi sila comparable, hindi sila same. So gagawa ka ngayon ng adjustment. Example, halimbawa na lang yung study mo, it resulted na yung arm's length pala is, dapat ang gross profit is 10%. Yung company mo, ang gross profit niya is only 5%, no? Lalo na sa cost plus markup, reimbursement of expenses lang. Ma-markup lang sila ng 5%. So, ang layo pa, kulang pa siya ng 5% para maging 10% siya, which is acceptable or arm's length. So, anong gagawin mo? Magbabayad siya ng additional na tax on the gross profit na 5% to make it 10% para acceptable. No? So, yan po yung purpose ng comparability adjustment. And then, on the 24 naman, we have free webinar on transfer pricing and taxation of digitized economy. So, yung discussion natin kanina na physical presence, ma-discuss natin yan ulit kasi ano ba yung landscape or yung ecosystem ng digitized economy, no? And then ano yung mga tax in the future na meron tayo. We must be ready, no? Ano yung ating source dito, the OECD, yung taxation ng digitized economy. Ito yung study ng OECD. And then we have the sa 25 yung transfer pricing and permanent establishment, no? So yung transfer pricing and permanent establishment, kailan ba nagiging permanent establishment ang isang company na mayroon siyang activities dito sa Pilipinas, no? Consider na siya as brand, so magiging taxable na siya. And then we have the transfer pricing and tax treaties. No? Right now, we have 43 uh, tax treaties with different countries. So, titingnan natin ano ba itong laman ng mga tax treaties na to. Kasi the moment may tatawag, ma'am, magkano ba yung tax natin? Ito yung company no from China, ito yung transactions dito. Ang sagot ko agad, you consult the tax treaty, no? Kasi pagka may tax treaty tayo, tax treaty ay consult natin. Pero pag wala, yung tax code natin ang i-consult natin, which is taxation on the gross. No? Then we have the international taxation and transfer pricing. Para sa akin, very important that you know international taxation because international na tayo ngayon. Whether you like it or not, yung domestic natin, wala na yan. No? Ano na tayo, affected na tayo ng international kasi ang purpose ng digitalization is one world, one economy. So, kung hindi natin aralin yung international taxation, maiiwan po tayo. And even then, sa mga CPAs, di ba, meron na tayong ASEAN CPA wherein pwede tayong mag-practice in 10 ASEAN countries. So, anong aralin natin yan? Lahat ng taxation ng 10 countries na yan, dapat alam natin so that pag gumawa tayo ng study, may mga client tayo, alam na natin i-apply, especially in the context of transfer pricing. Huh? Okay, shout out, Hari. Okay, so with that, I would like to say thank you and see you tomorrow po. No, I'm inviting you to attend our 10 o'clock, no? 10 to 12, 2 oras lang naman po siya on transfer pricing documentation.
Pag-register na daw si Miss Copy.
Naka-register na siya. Oh, ay, okay, sige. Thank you po. And then, para hindi tayo mahirapan pagdating na doon sa 1709. At saka pagdating na sa transfer pricing audit, hindi na rin tayo mahirapan. No? So, with that, I would like to say thank you and let's call it a night.